rise. The Court of Appeals Division 1 is now in session.
Thank you. Be seated. Good morning. Now is the time for oral argument in cause number 1CA-CV170704, Wilson versus Wilson. For everybody's information, the proceedings are being both audio and video recorded this morning. I'm sure you've all heard this before. So barring any unforeseen problems, you can critique yourself on YouTube in a couple of weeks. Counsel, each side will receive the normal 20 minutes. And we would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to save any of that time for rebuttal, please let us know. But ultimately, that is your responsibility to maintain. We've reviewed the briefs and conferenced the case this morning. We're well aware of the facts and issues attendant to the argument. We say that, and I always put a little addendum on here, that we say that so you can order your plan out your oral argument accordingly. Use the time to your best advantage. Counsel, when you come to the podium, I'd ask that you state your name and who you represent for the record, particularly since we're recording it. And with that, counsel, you can begin.
Good morning. May it please the court, Steve Everts on behalf of the appellant Wesley Wilson, who is present in the courtroom. This is a relatively straightforward spousal maintenance modification case, or at least what it should have been. So I asked the court, how do we take a relatively straightforward spousal maintenance case and end up with the questions that we do? And I'm going to make a few general observations and try and answer a few general questions.
Well, go ahead with your general observations, but I'm going to have a specific question for you.
I am sure you will, and I'll be happy to try and answer it.
In your general observations, you may want to focus on the precise nature of the evidence that was offered in the proceeding that's on appeal today and what claims it related to.
Okay. And I will look to the court to probably clarify if any questions that you may have as we go along.
Sure.
My general observations, please. How do you get to a place in a case which appears to be a relatively straightforward spousal maintenance case where a retired man with a disabling heart condition and who's been determined to be disabled, receiving Social Security of $2,030 per month, is now required to pay 40% of his income for spousal maintenance? How do we get to a place where a wife who earns over 3 times the amount of income of that same ex-husband gets any spousal maintenance at all? I would remind the court that generally speaking, when we talk about a spousal maintenance case, we're looking at one income earner that's less than the other income earner. In this particular case, the recipient or the payee is actually earning more than the payor. My third observation is, how does a judge who correctly finds a substantial and continuing change of circumstances in this hearing, justifying a modification of spousal maintenance, ends up entering an order in exactly the same amount of spousal maintenance as was entered in the previous order and in the decree?
Counsel, in truth, did he find the same amount, or did he lower the amount but then add the difference back in to do catch-up on what hadn't been paid?
She entered a $100 reduction and then added it back in as a spousal maintenance arrears payment. Correct? Arrears. Correct.
Will you grant that there's a difference between arrears and the underlying spousal maintenance order?
I will grant that there is a difference between $800 a month and $700 a month, but I will point out that's what the original order was $800 per month. The revised order in this particular modification was $700 plus $100 on the arrears. What I won't grant is that there were any findings that were entered by this trial court as to why that difference of $100 was somehow applicable in this particular case, because there are none.
Can you cite us to a statutory or a rules requirement that absent request findings are required?
No, I cannot cite you to a reason why findings are required absent a request, but I will tell you that I believe findings that were made have to be made correctly, and the standard is that they have to be not erroneous. And therefore, if the trial court enters an order where the findings are made, in this case, if you recall, Judge Reckart entered all of the findings under the 13 factors of 25319B, although none under the ones under subsection A. But she entered all those findings. And if you decide that you're going to consider the amount of spousal maintenance, which is what we're talking about, then you have to consider the fact that if she enters the findings, they must be correct and not clearly erroneous. There must be sufficient evidence, and they must not be inaccurate.
Was the argument that husband earns 1/3 of what wife earns before the court when it made its findings?
I don't know if the figure of 1/3 was made before the court, but I do know there was not only a request or a fact presented, but there was a finding made that wife earns more income than husband.
Well, more, yes, but was the evidence clear that wife earned several times what husband earned at the time the court made its findings?
Yes.
That was on the record.
Yes. The
Can you
AFI
point
of
to-
wife identified her income, and her information on tax returns was in there.
Just for time clarification, are we talking about the initial decree, or are we talking about the first modification or second modification?
Well, I'm here on the second modification, and neither one of those were appealed, so I'm here only on that one.
So on the second modification, then, did the court have it before it, clearly in the record, not just exhibits that might have been submitted, but was there testimony or other evidence brought to the court's attention that wife earned several times what husband did?
I believe there's sufficient evidence in that record. If you're saying was there words that were used
Well,
that
the
said
next
it?
question you can imagine is, where in the record will I find that?
And I'd have to go back and show you my citations because I've cited all the facts in the brief.
All right.
But we clearly know he was making $2,030, and the court found a substantial change based on his disability. We know he was earning $2,030. We know what wife's income, both from first two hearings as well as this hearing, that she had earned $32,000 in 1 year, even over $40,000 in a past year. So we knew her income. Whether there was a statement made that was 2 or 3 times what his income was, I'm not positive, but it certainly is evident from the simple mathematics and arithmetic of those numbers.
Okay.
And they're in the record.
So ultimately, you're really making two arguments, I think. One relates to the evidence of disability, which we'll turn to in a moment. The other is just that generally when you stand back and look at the relative income pictures of these two parties, the court abused its discretion under 319B.
I'm saying the court should have entered a finding that wife was not entitled to spousal maintenance under subsection A because she didn't prove either she was self-sufficient or needed reasonable needs, and under subsection B she had greater income than husband, correct, and therefore wasn't entitled to the amount and duration that was awarded.
But, counsel, if you rely solely on that, don't you end up with a situation where she's working 7 days a week, 13 hours a day, which I think counsel's going to point out is not something that should be expected in order to arrive at numbers that make it look like she's making twice as much as he is?
There's no dispute that wife was working 7 days a week in this trial court record and then had 3 jobs.
But you're wanting us to take that number and contrast it against his income, correct?
Well, I am absolutely, because the decree in this particular case, Your Honor, she was already working the 3 jobs at the time of the decree. This wasn't a change of circumstance for her. It was a continuing circumstance. She chose and elected to have those 3 jobs in order to make ends meet before they ever got divorced.
The court entered the award of spousal maintenance knowing what the circumstances were.
Correct.
And that wasn't appealed.
No.
So what's our continuing and substantial change of circumstances now that allows us to go back and question that?
Are you questioning the trial court's judgment and whether there was a substantial and continuing change of circumstance? Because that was a finding that Judge Reckert already made.
I'm asking you a question, which is, what occasion do we have to even ask the question?
The issue is that husband's disability actually occurred. He received actually the money from disability on Social Security, and his income dropped from $70,000 or $80,000 a year down to $2,030 a month.
Well,
That's not what Judge Jones asked you. What Judge Jones asked
Sorry,
you,
I misunderstood the question.
Okay, what Judge Jones asked you, and what I would like to know the answer to, is on what basis can we intrude on the finding under 319A that wife was entitled to spousal maintenance when she had 3 jobs and was working 7 days a week, if that was already before the court when it entered its original order and that was never appealed?
Okay. The reason you do that is because the court made a finding that there was a substantial and continuing change of circumstances. That doesn't just mean one circumstance changing. We only consider one factor under 25-319. That means we start over in the calculation of spousal maintenance. And our Supreme Court has said that we start over. It's a two-pronged test, and the first one is to determine entitlement, then the amount and duration. And in this case, there's not a word in this entire order about entitlement of wife.
We're mixing we're mixing arguments here. Let's take them one at a time.
Okay.
First is the argument that at the 30,000-foot level, this case just looks unfair because wife makes a lot more than husband, right?
Yes.
Okay. And that's a facially persuasive argument. The problem I have is if you make that argument under A, that was already decided in the original decree that was not appealed. So nothing about that disparity or nothing about wife's situation has changed. And so what's the basis to reconsider?
Well, her income had increased because at the time of the decree it was less than it was at the time of the modification, both of the modification orders. She'd also received a retirement benefit and paid out of over $40,000. So her circumstances had changed. But even if they were the same, the court is still required to determine whether or not she's entitled. Just because it was a finding in 2015 doesn't mean in 2017 that she's still entitled to the award if, in fact, her circumstances have changed and there's a difference in the justification for the award in the first place.
So there were two circumstances that you're saying changed. Number one, wife's circumstances got better. Number two, there was this disability ruling that related to the disability that was discussed in 2015, right?
It was discussed in 2015, yes.
Well, it was also litigated in 2015, and that gets to my specific question, which is why under this court's recent case in McClendon isn't that argument time-barred? It strikes me that the disability ruling is simply better evidence of a claim that was already litigated and lost.
No, because the court, if you look under the Linton line of cases, you can't litigate a prospective situation in advance. You have to wait until the circumstance occurs.
Sorry, the basis for introduction of the disability ruling was to litigate a disability that had already once been litigated. I don't see that the circumstances changed between 2015 and 2017. What I see is that the evidence got more clear between 2015 and 2017, and perhaps if this evidence had been available in 2015, your client would have won.
What's the you use the word prospective. What was prospective? What were the things that were to come in the future that weren't before the court in June of 2015?
Okay. In the decree, husband hadn't even quit his job. He was still working. He was not allowed to have extra overtime, and his doctors had said he should quit and he should retire. So he was still working.
Have an idea? Did the trial court know that in June of 2015?
In the first modification?
In the decree, in 2015.
They knew he had argued that he was going to retire and that he had had a health condition that had occurred.
Okay, so they did know, and they did consider it? Is that accurate?
I assume that they did consider it, yes.
Okay. Don't deny it was before the court.
I don't deny that was before the court.
How did that change, going to your word, prospective? How does that, what was prospective about that?
Prospectively, he had another heart attack. He had a finding, or he applied for disability. By the time of the first modification, he'd applied for disability, and it had not been granted at that time. So then he has the second hearing. Remember, Judge Thompson had denied the request.
Let's talk about the heart attack. The second heart attack. What is the impact of the second heart attack that would change what was before the court the first time, which is, I'm going to be retiring?
Well, before the court the first time, he hadn't retired. Before the court the second, in the first modification, he said he had filed for disability but hadn't been received. By the time of the third hearing, he'd actually received it. That was the basis upon which Judge Record then decided there was a substantial and continuing change of circumstances.
But what isn't the relevant circumstance his inability to work, not his receipt of disability?
Well, apparently not, because in Judge Thompson's ruling, he didn't find that he complied and had satisfied the substantial and continuing change of circumstances just because he had said he was going to retire and couldn't work. Right. But by the time that Judge Record heard it, she found that that was sufficient because he had, in fact, received the disability.
But receiving disability is not a change in circumstances. Inability to earn income is a change in circumstances.
Yeah, in this case, it was a change, Judge,
Well, it
because
might have been a change for the better, but the inability to earn income was what was litigated in 2015, right?
2015 at the time of the decree,
Modification.
first modification, he was still, the finding was that he still had the ability to work. In that particular modification, Judge Thompson said he still had the ability to work, even though his doctors had said that he shouldn't. So by the time of the second modification, he was actually no longer working, and he had received the Social Security. In fact, he'd applied for and received a disability rating so that he could receive the Social Security. That was not evident in the first hearing.
So the change is that the first trial court said, you can work. You're choosing not to work.
Correct.
And the
Voluntarily
second
choosing.
time, you're saying the court effectively said, you know what? You would read that, the second court, the second modification is saying, we understand now you can't work because the Social Security Administration has awarded disability benefits?
Yes.
That in and of itself is the court condoning or approving that yes, it was accurate, that you can't work.
That letter was an admission in evidence, and that was the finding upon which the court made the decision that he no longer could, that he had satisfied the substantial and continuing change of circumstances.
So
Go ahead.
So with that, we arrive at the point he'd already advised the court of that he was going to be retiring.
He had told them and argued that he was going to be retiring, but they didn't accept it because he had not actually done so. And he was able to work. That's what Judge Thompson made in the findings, if you read his order. Contrary to his argument, he said he could work. And he was capable of earning income even with his disability.
But I don't know that you can bifurcate those two things. Judge Thompson may have said he was capable of working. Your client said, I'm going to be retiring.
Right?
Okay. And then he retired.
Then he retired.
So is working still an issue as far as his core income goes?
Sure.
Because?
Is working still an income because of his core income?
No. Is working still an issue? If he wasn't going to be working, and he's not working, what's...
The court rejected that argument, though.
But
Just
they didn't
because he
reject
made the argument doesn't mean that he waives it in another hearing when it actually occurs.
That gets to my former adjudication question. The court rejected it, and now a new court accepted it. Isn't that the essence of what res judicata prohibits?
No. No, because the facts were different. Yeah, in res judicata, you have to have the same facts and same arguments that are being made.
Have the same facts?
No,
If you had to have the same facts, then anybody who got better and new evidence after they lost a trial could simply refile their case.
Well, you can't litigate new facts and say that's res judicata and what the old facts were.
Res judicata is a term that has probably rightly been abandoned in favor of the term claim preclusion. You have to have the same claims, not the same facts.
Correct.
And the claims here strike me as the same. The claim is, I can't work.
The claim was, I can't work. When he got to the second hearing, he wasn't working.
So
And
all
he'd
that
been disabled and had been... That is a different claim than it was before.
Wasn't he just as disabled in 2015 as he was in 2017? It's just that now he had the imprimatur of the federal government to say he was disabled?
No. They said, no, he wasn't the same.
Were disabled in 2017?
Absolutely.
Why?
Because he was not capable of working. And
But
had
that's
been,
what he said in 2015.
I don't believe the position is that because he makes the claim that is rejected in 2015 that bars him from making the claim again in 2017 if in fact he has retired in the interim.
Okay.
Okay?
Even if the first court understood that and accounted for that in their decision.
In the first modification,
Yeah.
they took it into consideration. They just said he could continue to work. That's what Judge Thompson ruled. That even though he was thinking of retirement, he hadn't actually quit, and he was still working and earning an income.
And that may have been wrong. I mean,
It might have been wrong. It probably was wrong.
And let's assume for a moment that it was wrong. Under the law, though, do you have the right to challenge that in a second proceeding?
I think he absolutely did because the facts had changed. Nobody has appealed Judge Record's decision that there was a substantial and continuing change of circumstances. What you're inferring by the questioning is that somehow she was wrong in making the decision. Nobody's asked this court to change that decision. We presume that for this purpose of oral argument. There was a substantial and continuing change. Now we're here to talk about, did she do the proper order after she made that decision? Okay? I've got 2 minutes and 15 seconds left, so I'll reserve the time for rebuttal if I may. Unless you have any other questions. Thank you.
Morning. If it pleases the court, my name is Roger D. Smith. I represent the petitioner, appellee, who I will refer to as wife. Wife is asking this court to affirm the lower court ruling and to award her attorney's fees on appeal. I think underlying much of the appellant's argument is the contention that the trial court committed a reversible error by not making written findings of fact with regard to whether she qualified for spousal maintenance. The reply brief cites Gutierrez versus Gutierrez for the proposition that findings of fact are required in every case, even if they're not, even if there's not a request for findings under Rule 82. Neither Gutierrez or any other case supports that proposition. The law is clear that findings of fact are required only if they're requested. If they're not requested, this court will assume the trial court made every controverted fact in favor of sustaining the ruling. In this case, the trial court awarded spousal maintenance. By necessity, it found that wife was qualified under the statute. So the only evidence is whether there was any evidence upon which that finding could be based. The law is clear that this court views the evidence on spousal maintenance in a light most favorable to sustaining the award.
Well, let's take a look at, let's turn on that light and look at the evidence. If the evidence is that wife makes 3 times what husband makes and husband is disabled, setting aside 319A for a moment, how is that sustainable under 319B? How do we say that that's an appropriate exercise of discretion?
Well, there are several different factors here. One is it beyond the bounds of reason for the trial court to conclude that a 58-year-old woman should not have to work overtime 7 days a week in order to make ends meet, particularly when it was already determined that she gave up career advancement to devote herself to a family for 30 years.
It may be beyond the bounds of reason if another court determined that 2 proceedings ago and that determination wasn't appealed. All right. In other words, wife has this consistent history of significant employment. She works hard, and she did at the time of the decree.
Correct.
Okay. And there was a finding that under 319A that she was entitled to spousal maintenance.
Correct.
That I'd like to set to one side because, candidly, I view that as having been decided. But when we talk about modification, typically we're focused on B. Not always, but typically we're focused on B. And under B, when the circumstances are, husband is disabled, he's not working, he makes 1/3 of what wife makes, and the award is that he pay a significant percentage of his current income on an ongoing basis without any apparent end. I'm struggling to find that favorable light under 319B.
Well, when you say without an end, the award does have an end.
Well, but the end is not imminent.
Okay. At the time of the trial, the original trial, it was known that the husband was retiring and that he would get his retirement benefits within 60 days. He filed a petition for a modification in which he claimed he had suffered a post-decree heart attack, could no longer work, and had applied for benefits from Social Security. The court determined at that time he could work. He voluntarily quit his job, and he was in contempt of court for willfully not paying what he was supposed to pay. he didn't appeal that, and he just waited 3 months and filed another case. And in his petition, he's alleging that he became disabled prior to the last order.
Which gets to the McClendon issues that I raised with your colleague, but what I'm asking you still is, if the facts are, as I've laid them out, and I haven't heard you dispute them, in today's world, the facts are that there's this fairly significant disparity of income. I'm struggling to find an example of an appropriate application of 319B that leads to this result. I'm struggling to find a case that says, given this disparity of income, even if there was a finding at one point of entitlement under 319A, that this sort of award can be sustained given that disparity of income. Can you help me?
Well, the ruling on the first petition to modify is that the husband is capable of working. So the fact that he has a lower income than wife is because he chose not to work. The only thing that happened subsequent to that is he started to get additional money. He got federal benefits. But there's no connection between, I mean, he even admitted at trial that you can work and still qualify for benefits under Social Security.
So the second judge, the second modification, also found that husband can work but just isn't?
The second, there were no requests for findings, so there's no specific finding.
So they didn't
So they didn't
tackle
say
that.
it one way or the other. But the only thing before the court was, we've already determined he's capable of working. The only thing he's saying now is, now someone's giving me more money. He didn't bring in any evidence at the second modification to show that there's been a change in his condition. In fact, his argument is that it was the same as before. His argument was, I'm entitled to a modification because I'm disabled, and I became disabled before the last ruling, and the reason I'm filing this in his petition, he says, I'm filing this because the first judge didn't believe me. So he's taking a second bite of the apple on the same facts. There's no change in circumstance.
I hear you, and obviously my questions under McClendon were directed to just that point. But my question still goes, the question I asked you still goes unanswered.
Well,
Where is the case, where is that favorable light that says that the judge's computation on the second modification under 319D was an appropriate exercise of discretion
because
on these facts?
there's no finding that he's incapable of working. The only finding is that now he's getting.
Let me refocus you on my question, which is, when you have this sort of disparity of income, do you have a case that says an award that represents a substantial portion of the payor's income is appropriate?
Well, I guess I can't cite you to a specific case right now. I'll tell you that the law is that you can't avoid your obligations just by voluntarily quitting your job,
Right,
which is the finding of the court.
And well, not in the second modification.
Well, but
in the case that we're appealing, or that we're hearing today, the court did not find that he was willfully avoiding his obligation by willfully not working.
well, it didn't find that he's not capable of working either. It just it tweaked the award, reduced it by $100, but it didn't say he's not capable of working. So the only thing that's happened is,
Did it infer that the court found that he was capable of working?
correct.
I mean, that's quite a leap, given the evidence that the court had and the fact that it made a reduction in the
Well,
award.
the evidence it had was that the only evidence he came to court with was, now Social Security is giving me additional money. And he says they wouldn't do that. In the reply brief, they say they wouldn't do that unless he was incapable of working. But at the trial, the testimony was, you can get Social Security benefits even if you are capable of working. So there's no evidence that he can't work. There's no medical evidence that says now his condition has gone south since the last hearing. There was a specific ruling saying he can work. There's no ruling that says he can't work, and there's no evidence that says he can't work. It's just, well, now that the Social Security Administration is giving me more money than I used to have, I shouldn't have to pay anything. So his change of circumstances is he's in a better financial position than he was at the last hearing.
So, counsel, what you're suggesting is that the circumstances at the time of that hearing, the court might have interpreted as him being in a better financial position than he was at the time of the original order?
The court could have made that.
Then why did it reduce the award?
I can't answer that question.
So you're
just because
suggesting that we infer that the court found that husband was willfully evading the opportunity or the obligation even to work, but it reduced the award.
Well, you can infer that if it reduced the order, that it may claim that his ability to work wasn't as great, but you can't infer that because the court ordered him to continue paying spousal maintenance that it said that it concluded that he's incapable of working.
Could you infer that the court abused its discretion?
No, I don't.
I mean that's a possibility too, right? When confronted with fairly stark economic disparity and the order goes in the opposite direction of what you would normally expect. I mean, if presented with these facts at the initial dissolution proceeding, one could easily imagine husband receiving maintenance, right?
If what I would have expected, I mean, if we're going to talk about what we expect, I would have expected the court to say, when you file a petition saying that I became disabled prior to the last ruling that said I am capable of working, I would have expected the court just to dismiss the petition as a matter of course.
Well,
he is
counsel, let's focus on that second modification. And I have, at least here in the briefs, this is the reply brief on page 18. It's citing the order, and is this what the court found? Husband's, quote, husband's health has deteriorated since the original award was granted, making him dependent on disability and Social Security. Is that what the court said?
That's what it said. And
now let's get back to your argument that court, we can infer, is saying, oh, he can work. But didn't they say he's making him dependent? I mean, how do you reconcile those words in the court's order with your argument?
Well, I would say you have to look at the entire. I mean, you could, if you read that sentence, it's hard to make that the conclusion I'm making. But you have to look
harder when you read the result.
No,
when you couple that sentence with the result, it gets really hard to tease out a finding that husband's deliberately avoiding working.
Well, so then the result then is that because wife chooses, because she has to work 7 days a week overtime, that he's entitled to a reduction in his spousal maintenance because she chooses to work harder.
So you're saying that there's the potential in the law for the court to say because she chooses to go out and increase her income and nothing's changed with him, if this is what the court's finding, that he can still do what he used to do, that alters the circumstance because you can go back and alter the original consideration in the granting of the spousal maintenance?
Well, I think it's fair to say that the court can conclude that the wife is not under an obligation to work 7 days a week.
Okay. And?
I think the court
No court has ever said that, of course.
But I think the court took all the factors into consideration. This is a discretionary call. It took into the fact that she's working hard. It took into the fact that he's making less money. And it juggled the various factors and came up with a spousal maintenance order.
But of the three courts who have heard this case, none has said wife shouldn't have to work so hard. She works hard. I mean, that is something that some people do. And no court has criticized her for it or suggested that she should be somehow relieved of the burden of employment.
That doesn't mean the court can't take that into consideration. I mean,
But that's speculation. After 3 judges, you would think, if your point were valid, if that's really what the courts have been thinking along, that somebody would have said so.
well, if the court awarded her spousal maintenance in the first place when she was working 3 jobs and working overtime 7 days a week, I'm not sure that's exactly what was found at the first hearing. That was the evidence at the third hearing, that she was working overtime. She may have had 3 jobs, but the testimony in the current proceeding was she's working overtime 7 days a week. But
Counsel, based on your consideration of all these theories that might have occurred, I believe your client sought $1,500 initially in the course of the divorce.
right,
She was
for
given
an extended period, I think 15 years,
and instead she got $800 a month
for 7 years.
How does that calculate into this issue of what the court may have been considering and where it may have put its emphasis? Because they cut her way back on what she was asking for.
Right, because they considered the fact that the husband had claimed he had physical problems and he was retiring in 60 days. He wouldn't be able to make as much money. So they did consider that. They considered all these factors.
Let me ask you, shift gears to the retirement. Okay, so we have at the first modification, the court recognizing, quote, that there's a significant amount of retirement, end quote, on the horizon. Is that accurate?
At the
first, at the outset.
right.
Right. And then the change at the second modification is we have a liquidated sum, a sum certain. Is that accurate?
Well, that would have been accurate at the first modification.
Okay, so the sum was known, that sum certain was known at the first modification, and just describing it as a significant amount was just an adjective rather than using the word, the number.
Correct. It was known at the time.
Okay.
The retirement was 60 days after the original decree. The first petition to modify was filed 90 days after, and the order dividing the account was like 6 months before the trial in the first petition.
Okay. So it wasn't just the fact that we all understand there's money on the horizon. We know how much it's going to be, and the court actually had that in front of it at the outset. Okay.
Correct. Plus, there's no requirement that the court force someone to exhaust their retirement benefits in order to qualify for spousal maintenance. I mean, the purpose of retirement is that when you are no longer earning an income, you have money to live on.
Right.
So,
No. What I was trying to get at is what was the change, to use your counsel's, opposing counsel's word, the prospective component, what they didn't know then that they knew now. And you're saying they knew what the number was both times.
Yeah, they knew. And unlike the cases cited in the reply brief about changes that happen years out, it was known at the time of the original trial the retirement benefits were going to be paid in 60 days.
Did they know the amount of those benefits? It seems to me like the evidence was pretty scant in this case.
I don't know for sure.
So you don't know if that was a financial consideration the court made. They just simply made the factual determination that there would be a retirement.
Right, but they did know it at the time of the first modification. So now they're coming back and arguing at the second modification that she got something that they knew about at the first one.
Okay, so we're going back. They did know at the first modification. You're saying at the decree stage, it was just sort of, it's not clear. The evidence isn't clear whether they knew But you're saying at the first modification, they knew to the penny.
Correct.
Okay.
I have 4 seconds if there are any additional questions.
Something pivotal, counsel.
Thank you.
Thank you.
In my last 2 minutes, I want to address the questions the court asked previously and answer them. First question was whether or not there's a citation in the record, whether or not the husband had said it was 3 times. I refer the court to pages 32 through 35 of the transcript and 67 to 70 where wife testified about her income, and specifically page 34, lines 24 to 25, when husband was asked, and in fact her income is higher than your income, question mark, answer, by a third, which I think he meant 3 times. So that answers that one question. Second one is to do with res judicata. I want to make sure it's clear. I don't remember that argument ever being raised in the answering brief. I went back and just checked it. I don't see it being raised there.
You're right.
Nor is there a McLennan case cited in anything that we've done so far. So in order to be able to do it, I mean, I don't know whether the court allows this or not, but I would brief that issue if it becomes critical in the decision of this court, because it has not been briefed for the court so far. Third thing is, the court made no findings under B, 4, 5, and 9 for husband's needs and his ability to pay, or wife's needs and her income and assets. Those factors had to be done because she already entered findings, and they have to be correct and they're clearly erroneous. Last is the incorrect finding that the trial court made. If you remember in the minute entry, this is the one where she said, although husband's income has been reduced, this is number 5 in her ruling, husband's unwise purchases and other financial obligations contributed to his reduction in income. And I want to dispel this notion that for some reason the husband was required to use his assets, and he wasn't allowed to deal with them some other way in this case, but he was supposed to save them and keep them intact so he could make income on them and pay wife's spousal maintenance. That whole notion to me is contrary to the whole idea of how you define community property in Arizona. If we presume in the decree that each party received half their assets, our Supreme Court has said they can do with them as they please. They do not have to preserve them for the other spouse. And to pay her income off of his assets and somehow punish him for buying a house and buying a truck would be completely inappropriate with his use of the assets, because he would be then converting what was given to him as his half into spousal maintenance for wife.
Counsel, wasn't the criticism not the spending of his assets, but the incurring of the ongoing debt? There was debt load that went along with the improvements that were made to the house, the cost of the car, and I thought that was what the court was addressing.
He took $100,000 and paid them in cash, as any retirement person would do, to reduce their debt load going forward so that he didn't have debt.
So there was no debt attributable to the expenses of incurring the house and the modification and repairs to it.
Bought the truck free and clear, paid the maintenance, paid the charges for the house, and took care of them.
All right. Thank you, counsel.
Thank you.
It's always interesting. Counsel, thank you for your argument today. We appreciate it. We appreciate the way you've approached our questions. We're going to take the matter under advisement at this time. We will render our decision in due course. Thank you. We're adjourned. This matter is adjourned.